Here today is September 27th, 2022, and the court is hearing three arguments by video conference today. The first being State of Ohio versus Kenneth Grad. As you can see, the panel is Judge Hensel, Judge Callahan, and myself. I'll be presiding and keeping time. So if you are going to reserve time, Attorney Ferrara, let me know and I'll interrupt you and let you know as you get close to your rebuttal time. Each party will have 15 minutes to present their argument. As I said, you may reserve up to 5 minutes for rebuttal as the appellant. The arguments are recorded. They are posted on our YouTube channel, so we ask that you keep your voice up. And if there are minors or children involved, we ask that you not refer to them by names. Same thing with victims. Other than that, I can assure you that we've read the briefs and we are prepared to proceed if you are. So let me start off by asking you, are you going to reserve any time, Attorney Ferrara?
Yes, I'd reserve 4 minutes for rebuttal.
4 minutes. All right, I'll let you know as you get close to that time. Go ahead, you may proceed.
Thank you, and may it please the court, my name is Rick Ferrara for Kenneth Grad today. We have an interesting case today on a motion for leave to file a motion for a new trial in Mr. Grad's 2014 case stemming from a conviction in which it was found that he caused fractures to an infant about 2 weeks old. Now, what has happened since the 2014 trial has been significant. We have had multiple studies come out, a study in 2021, 2019, 2017, and 2016, investigative reports regarding infant trauma and how it comes about and how it does not come about from the Washington Post, a local investigative report by WKYC specifically about Dr. Steiner, a principal witness in this case, Grad family history, and a change in the cost of whole genome sequencing, testing that could be done in a case such as this and in light of the studies. All of these things have happened, and they went into a large motion for leave to file a motion for new trial. The trial court did abuse its discretion. I asked this court to reverse for that abuse of discretion in denying the motion for leave to even have a hearing, because the evidence presented in that motion for leave was sufficient as a matter of law to present a prima facie case that Mr. Grad was unavoidably prevented from presenting any of this. Largely because the studies did not exist. I mean, they could not have existed. And in a case like this, there is a long march of science that occurs even beyond a trial, beyond this 2014 trial. And that's kind of what happened here. I think the state has responded in some of the trial court's statements regarding the reasonableness of time in which we presented this information was one of the initial responses of the court and the state of Ohio. The Ohio Supreme Court has settled that matter in State versus Bethel to hold that there is no reasonableness requirement. And I included that in my reply brief for this court to review. Obviously, it's, you know, you've all seen it. And it's an interesting change for my client, largely because we don't have to argue that portion anymore, although I thought that we met the standard anyway. As for the information that was presented and that it was my client was unavoidably prevented from presenting it, the reason is the backdrop of this case and how, in going through the trial transcripts and having read the trial, the case was developed not based on testing. The conviction was based not on testing necessarily, but on medical conclusions that testing was unnecessary. As this court knows.
Counsel, hang on. I just want to make sure I understand this. I thought that the state had tested for brittle bone disease.
And that's a good question. Technically, that's true, Your Honor. They tested for a single genetic variant of osteogenic imperfecta, okay, in which there's multiple variants. They did a physical test, which the state has alluded to, of WG for EDS. However, there are no genetic tests done, meaning the testing is limited to that physical test and a single variant of a single genetic disease. And that's the important point, because, you know, when Dr. Steiner was questioned on these things, his testimony essentially, as I quoted and I provided to the trial court, stated that it was unnecessary because the genetic possibilities just didn't exist medically, right? The conclusions the state's expert witnesses were stating was broadly, these things couldn't exist in WG. Therefore, there is no need to test them. And that's the explanation for the state's case that rode to a conviction.
Okay, I need to ask you another question. Because I assume, and you know what they say about assuming, but you quoted some of Dr. Steiner's testimony in the brief. And it seemed to me, and again, I haven't read the whole record, only what you quoted, but what Dr. Steiner was testifying to was basically ruling out vitamin D deficiency in utero as being a cause. I did not get the impression that he was ruling out the possibility of other issues that could be genetic issues, which is to me kind of apples and oranges from your 2021 report.
I see.
Did Dr. Steiner actually say couldn't have these genetic issues in utero?
Yes, and that's why EDS testing wasn't done. So there's a question that came up to Dr. Steiner. What about genetic tests for EDS? This is not EDS. This boy's bones are perfect. He doesn't have EDS. And so and the state of Ohio then was asked to answer for that, right? And you see the quote that I excerpted from that. They said, listen, we just don't, the chance for payoff on this is not high enough for us. We're not paying for these tests. And the quote was, we could test them till the cows come home, but we're not going to do it. And so that is the essence of it. So as far as the genetic diseases, OI and EDS, right? There was, a partial test, because only a single variant of OI was tested genetically with genetic sequencing, any sort of genetic science. And as far as vitamin D deficiency, there were no measurements taken that the state could use. So they assumed, Dr. Steiner's testimony is that he assumed, as you noted, you saw in my excerpt, assumed that vitamin D could not occur at this level. And so,
counsel, in terms, I'm sorry, I know you have limited time. This, as you said, this is very interesting. In terms of the testing or lack thereof, my recollection is that there actually was a request from the defense, and that was denied by the court, correct?
Yes, several. I think there are upwards of 3, yes.
Was that assigned as error in the appeal?
It was assigned as error in the appeal, yes.
Thank you.
Yeah, and so and so the question naturally is on a motion for a new trial, what has changed, you know, and how significant are the studies? Well, they're so significant that in the 2021 study, there were more genetic markers found for a child with infantile rickets, interuterine bone disease, right? And so we have these new markers that exist, and then the excuse for not testing is gone. So as I've noted, you know, I mean, it was $10 million to test WG for whole genome sequencing, everything at the time of the start of this prosecution in 2007. At time of trial, even for whole genome sequencing, which wasn't even discussed, it was 10,000. Okay, even that was the cost for a single genetic test at the time for a single disease. Now testing for everything is less than $1,000. The entire WG's entire genome, and so, you know, the response from the court and from the state of Ohio at the time of the trial was, hey, it's just too expensive anyway. It's a shot in the dark. Not anymore, it isn't. And so not only do we have these studies that have all gone in one direction, all gone towards the defense. The 2019 study is a great study on vitamin D and prevalence in infants who have multiple fractures. It shows up. And that's something that Dr. Steiner said didn't occur. In the 2017 study, you see the connection not only between vitamin D, but also OI and EDS. All these occur. Now,
Counsel, how do you reconcile the positions in those studies with the fact that several of those experts were there at trial available to testify? As I'm weighing the case law, a lot of the cases you brought forth, it looked like nobody ever even tried to get expert testimony for the defendant. That's not the case here for your client. And I'm having some difficulty reconciling that, because it seems that your experts have the same opinion.
Yeah, and I think I look to State versus Epps in that regard, in that the development, I mean, you know, the quote is from the Court of Appeals, I think it was the 10th District, who said, the arguments are similar, but the science has changed, right? And that's happened with shaken baby syndrome across the United States. Listen, I mean, the arguments that shaken baby syndrome wasn't a viable way to diagnose a child 20 years ago, that argument did exist. It has new weight and force now when you have a Washington Post story and you have all these studies here in this particular case that show the science that was talked about 20 years ago can be seen as impossible by a jury. And so, yes, the arguments do share the same, I suppose, flavor, there's the same kind of color to them, right? But man, have they changed substantially when you can point to a study of 75 infants now who contradict the state's, you know, opinion of the case. And they do change in light of the way that this conviction was had. I agree that the experts were there. And at the time, it was a battle of ideas about and theories that weren't necessarily locked down by the defense at the time, the defense expert. But that has changed. I mean, these ideas are no longer theories. They've been shown.
Well, is it locked down now? Because I get the impression that it's, well, let me just leave it at that. Is it locked down now?
Well, they can create doubt, Your Honor. Before there wasn't such a there was a tactical decision made by counsel, right, to not bring these people in, and now you have data confirmation of these ideas, and that is different, especially in the face of the state's case, which did not rely on testing. And if there's any question by anybody, there is no excuse this time not to get tested. No.
Counsel, you're at 3 minutes and 23 seconds left for rebuttal. Do you want to continue or do you want to save that time?
I'll reserve the remainder of my time for rebuttal. Thank you, everybody. We do ask for reversal. Thank you.
All right, thank you. All right, 15 minutes, counsel, go ahead.
Morning, Your Honors. May it please the court, I'm Vince Felucci with the Medina County Prosecutor's Office on behalf of the appellee of the state of Ohio. His sole assignment of error, Grad argues that the trial court abused its discretion in denying his motion for leave to file a motion for a new trial. When Grad filed this latest motion in October of 2021, it had been about 7 years since his December 2014 trial. In the motion, Grad cites studies from 2016, 2017, 2019, 2020, and 2021. It's unclear why Grad could not and did not file a delayed motion for new trial in 2016, 2017, 2019, or 2020. Grad's motion was based on evidence that he could not and still cannot demonstrate is newly discovered. Grad doesn't explain how or why he was unavoidably prevented from discovering the 2016, 2017, 2019, and 2020 studies until now. The fact is that he wasn't clearly and convincingly unavoidably prevented from discovering this alleged new evidence that he tries to rely on now. This court has held, quote, a defendant is only entitled to a hearing on a motion for leave to file a motion for new trial if he submits documents which on their face support his claim that he was unavoidably prevented from timely discovering the evidence at issue. Well, he didn't do that. The experts Grad cites, as has already been pointed out, are the exact same experts he cited in 2014. Those experts' subsequent studies should not have been difficult for Grad or his counsel to discover, given that he was already familiar with them and their work. As you said, they were retained at the trial level. They prepared reports, but the trial strategy was, the decision was made not to have them actually testify at the trial. And as I've said over multiple, in the direct appeal, post-conviction, that was a very reasonable trial strategy. And I'll get into that more. And I would direct this court to its own decision, pointing out just how well his trial counsel did cross-examining the state's experts and pointing all these exact same things out that he's trying to point out now. That did not persuade the jury then, and it would not persuade the jury now. It would not change the outcome, because what happened is the state's experts actually tested WG, who had these 26 horrific fractures, actually tested WG and ruled out the conditions that he's trying to suggest really caused this. Grad's experts never tested WG, and they never will test WG. Grad presumably delayed in filing this motion for so long so that he could build a stronger case over time. However, several appeals courts have said that Criminal Rule 33B absolutely does not allow a defendant to wait for further evidence that will arise to bolster his case. You can't just sit on evidence that you know is there and try to accumulate it over time. And then that also has the benefit, of course, for the defendant of the farther you get out from trial, the harder it becomes for the state if they ever have to retry the case to locate witnesses and so forth. I know this court is well aware of that. And that's part of the strategy often too in these. And that's why you can't just sit around and wait forever to file these.
Let me just ask a quick question on the testing issue that you said the defendant did not have the victim tested. Is it true that they requested on multiple times the opportunity to have that testing done?
No, Your Honor, I don't believe that's the case. So what the defendants had was wild theories about what could have been, not facts and tests of what actually was the case. While the experts, Grad sites, have conducted more studies since the trial, the result is the same. They're theories in hindsight about conditions that theoretically could have caused all these fractures. That kind of evidence, again, would have very little probative value, but it would be highly prejudicial to the state of Ohio because it would almost certainly confuse and mislead the jury. The state of Ohio's experts at trial were not operating on mere theory. Again, Grad had this same type of evidence prior to trial and opted not to present it. Grad and his trial counsel instead opted for the reasonable trial strategy of relying on cross-examination of the state's experts. And they pointed out at the time in this cross-examination that there were additional tests that could have been done. There were. And that did not persuade the jury. It would not persuade the jury now. Or at least it can't be shown clearly and convincingly that it would. We know that new scientific studies and newspaper articles come out all the time. That clearly doesn't entitle defendants to new trials. If it did, Your Honors, an incalculable number of defendants would have to be given a new trial, and the criminal justice system simply would shut down. If you go to the Petro test, this so-called newly discovered evidence, as I said, does not disclose a strong probability that it would change the result if a new trial was granted. That's the standard, and that's a high bar.
I have a question for you. In terms of the theories, yes, I think what you said is true, but You also said that the defense and back then and now, you said never, they didn't and never will test that child. How can they have anything but theories in light of the fact that they have never been able to and never will be able to test that child? It's not like they can get an expert who says, I diagnosed this, and now you have, the battle of the expert in that regard. And it seems like they can have nothing but theories.
Well, if you're suggesting they test the child now, and I guess the
I'm
child
not suggesting anything. I'm just asking a question.
Well, I think you would have to test the child back then. At the time this was going on, because I think it is time sensitive, and these things can evolve over time. Certainly, it would be prejudicial to the state of Ohio to have the child tested now when they're 7, 8 years old or something like that. To assume that they're the same now, and that these diseases wouldn't evolve over time one way or the other, I think is just an absurd notion. The fact is he wasn't tested at the time, and there will not be testing. This is always going to be just wild theories on Grad's part. The state of Ohio ruled out had testing done by their experts of WG at the time, and ruled out these theories about conditions this child could have. And again, none of Grad's experts could have convincingly testified to an alternate cause of WG's injuries in 2014, and none can do so now. In fact, Grad even admits that the most recent studies he cites don't present any new theories of what happened to WG. They, quote, affirm Grad's theories from the time of trial. That's exactly the kind of evidence that the Petro test says you cannot, that does not justify granting somebody a new trial. Looking at some of the other Petro factors, Grad's evidence is merely cumulative to the evidence he could have presented at trial. And also, it seeks only to attempt to impeach the testimony of the state of Ohio's experts. Again, that is exactly the type of evidence that Petro holds does not warrant granting a defendant a new trial, and certainly not seven years out. And I realize that there is this Bethel case regarding it does not have to be necessarily within a reasonable time, but still you have to have evidence that you can demonstrate is newly discovered. I think that a large component of this, you do still have to look at time. And again, you have the first study in 2016. Why was this motion not filed then? 2017, why was the motion not filed then? 2019, why was it not filed then? 2020, why was it not filed then? So he's got to be clearly and convincingly unavoidably prevented from discovering this alleged new evidence. I still haven't heard what was the roadblock, what was the impediment to him discovering this evidence. The fact is there was none. This case has been in litigation. There's been attorneys on this case since the trial happened. There's been a direct appeal. There's been a post-conviction, the whole process, all dedicated to getting these experts in front of a jury that did not get in front of a jury at the original trial due to his reasonable trial strategy of not having them. And I think if you look at the actual cross-examination that was done, and it was well done by the defense attorney, all of these things that he'd be pointing out now were pointed out through cross-examination, through the closing argument by the attorney. And I would I would certainly suggest that this court go back through that because and think about what would really be different in the arguments now as opposed to back then. There's always other tests that could be done, and the jury knew that. The fact is, the tests that were done ruled out those conditions at the time, and those were facts and not theories, which is what you would have then and what you would have now from Grad's experts. And if there are no other questions, State of Ohio would just ask this court to affirm the judgment of the trial court. Thank you.
Judge Callahan, any questions? And Judge Hensel? No? All right, thank you, Attorney Viglucci. And 3 minutes and 23 seconds for your reply.
Thank you, Your Honor. First of all, let me clarify. Appellate brief, page 6. An order from June 27, 2013 denied the defense request for testing. So let's clarify that right now. The state's position is that we didn't test him, so therefore his case is based on theory. And Judge, your question hit the nail on the head. The state made this case how it was. They didn't test. They prevented testing. They made the defense go into a theoretical defense of whatever happened. And the conviction is thus based on these theories and broad ideas about medical science that have been proven to be wrong, convincingly proven by at least the 2021 study and all the rest of them as well. Now, if we look at the opposition to this motion, the state of Ohio does not present opposing medical experts. They don't talk about how the new medical studies don't meet the burden. They don't even quote the medical studies. They present nothing to say, except for their own opinion, that the medical studies aren't sufficient. And today you hear the state of Ohio say, it should not have been hard for Kenneth Grad to get these studies. Well, I can tell you with certainty, the baby born in 2020 that was available for the study for Dr. Hollick's 2021 study was not in existence in Kenneth Grad's 2014 trial. It is impossible for him to have found that baby. It's also impossible for Kenneth Grad to have himself studied a series of infants, 75 infants, in the 2019 study, for which many of the infants didn't exist yet. The same thing with the other study. What was it? The 2017 study. That case series post-dated my client's trial. The evidence didn't exist in the form of medically available children to study. And so that's what takes time, right? These theories flesh themselves out and then people study them. And it turns out that each of these studies disproved the state's theory, right? That was based on theory only, right? Because they only tested one genetic variant. What does State versus Bethel say about this and the timing? State versus Bethel unequivocally says, you can wait as long as you want. There's no reasonableness requirement. That's precisely what Bethel finds, because it makes entirely a great amount of sense that a person sometimes takes time to get evidence that frees them, right? And why should it be that the evidence, if compelling enough to summon a motion for new trial or to allow a motion for new trial hearing, if it's that compelling, let's hear it. This parade of terribles, this circumstance in which cases are overturned all the time, never happened. New medical studies don't come about quickly, but they sure do make an impact in our understanding of convictions based on shaken baby syndrome, based on DNA evidence, based on ballistics, right? This evidence changes all the time. And if we could free a person because the medical science changed and we understand better now, we should. This does present a prima facie case because there is medical evidence within WG that doesn't change over time. his genetics. WG's genes haven't changed, and they're certainly available for testing right now by snipping a piece of his hair. And so that testing for less than $1,000 should compel everybody to say, did we wrongfully convict Kenneth Grad on evidence that Dr. Steiner did not understand? I would submit to this court that the evidence presented in the motion was sufficient to present a prima facie case and get a hearing on the matter. The trial court was not authorized to not hold a hearing based on this compelling evidence. The trial court, based on the prima facie case, should have held a hearing, had to do so, and could not make a substantive conclusion based on the evidence without hearing it. But that's what the trial court did. And so,
Counsel, you've used up your time. If you want to just wrap it up.
thank you. And short of any questions, I'll conclude. These are the kinds of cases that need to be heard again. You know, this is the kind of thing that needs to happen when science changes the understanding of a case. And because this case is based exactly on how the state designed it, based on medical science and supposition only, it should be subject to challenge. Thank you very much.
Thank you both for your presentations. Court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail each of you a copy on the day the opinion is released, and the opinions are posted on the Supreme Court of Ohio's website. On behalf of Judge Hensel, Judge Callahan, I want to thank you both for your arguments this morning. Very interesting issue. So thank you, gentlemen.
Thank you, Your Honors.